두 번째 강연 시리즈를 시작하도록 하겠습니다. 오늘은 러셀 피트만 박사님께서 아주 흥미로운 두 경쟁법 사건에 대해서 미국에서 어떻게 처리를 했는지에 관해서 설명해 주실 것으로 기대하고 있습니다. 첫 번째 사건은 AT&T Time Warner 합병사건, 그리고 두 번째 사건은 아멕스 판결 사건입니다. Dr. Russell Pittman is the Director of Economic Research and Director of International Technical Assistance in the Economic Analysis Group, Antitrust Division, U.S. DOJ. And Dr. Pittman is also a very well-known scholar, and he has published a large number of articles in scholarly journals. And Dr. Pittman consults regularly with antitrust enforcers and economic reformers in transition and developing economies, most recently with the Federal Anti-Monopoly Service in Russia, and Romanian Competition Council, and Indonesian KPPU. Today, he will explain the two interesting antitrust cases in the States. And please welcome our guest, Dr. Pittman, and give him a big hand.
Thank you very much, Professor Kim. It's certainly my pleasure to be here again for the second time in my visit to Korea University this year. I do want to emphasize strongly that I am speaking for myself here. I am in Korea not as a representative of the Department of Justice, but as a visiting professor on my own time. And the views I'm going to express, as I'll probably emphasize more than once, are my own views, and certainly do not claim to be those of DOJ. So please understand that I'm sharing my own views. I should give a mild correction to Professor Kim's introduction. Somehow he got a hold of an old biography. It's been a very long time since I've worked with the Federal Anti-Monopoly Service in Moscow, but I'll get you the new biography afterwards. But today, as Professor Kim said, I want to talk about two, I would say, probably of the most important competition law cases we have had in the U.S. in recent years. By coincidence, they are both cases that the Department of Justice lost, and that was important, but there are many important lessons to take from them, and I think it's very useful to examine the details of the case that DOJ brought and my own thoughts perhaps as to why we lost the case. So I want to start with the American Express decision, the AMEX decision. Are we showing the slides? Okay, and can I control them? Okay, next slide, please. So, DOJ was investigating, along with several state attorneys general. We were investigating Visa, MasterCard, and American Express for the anti-steering provisions of their merchant contracts. And these were provisions, they were basically non-discrimination clauses that prohibited the merchants from providing discounts or even in other ways encouraging customers to use one credit card versus another. As I understand it, I didn't work on this case, but as I understand it, the main target was the Discover card, which had entered this market and was trying to gain market share by charging low fees to the merchants. But these contracts prohibited the merchants either from giving the customers a discount if they used the Discover card, or from putting a sign on their cash register saying, "We prefer Discover," or anything along those lines. Well, Visa and MasterCard settled and agreed to remove that provision from their contracts with the merchants. But American Express, or Amex, refused to settle. So DOJ and several states took them to court and argued that this was an illegal term of those contracts. DOJ and the states won in the district court. All of our cases at DOJ go straight to a general U.S. district court, not to any kind of specialized court. But AMEX appealed, and the appeals court overturned the district court and ruled that AMEX should be the victor in the case. DOJ decided not to appeal this decision, but the states appealed. And so the case is generally referred to as Ohio versus American Express. The states appealed to the Supreme Court, and the Supreme Court affirmed the appeals court ruling. In other words, also decided in favor of American Express. Next slide, please. So let's have a little economic background. Credit cards are a prime example, a perfect example of what we have called for years a two-sided market. Two-sided markets are defined in different ways, but certainly one way to define them is that the demand on one side depends on the price on that side, but also on the quantity on the other side. So that if you want customers, if you want individuals to carry your credit card, you want to give them a low price, maybe zero price, maybe negative price, but you also want to have a lot of merchants that will accept that card. Otherwise, it's not worth putting it in my wallet. And if you want a lot of merchants to accept that card, you want to have a merchant's fee that is acceptable, affordable, but you also want to have a lot of people carrying the card. Otherwise, it's not worth a merchant's trouble. So there are what we call indirect network effects. That is the change in the number of participants on either side, excuse me, in a two-sided market affects the willingness to pay and the demand on the other side. And this leads to what we call a chicken and egg problem, which is to get merchants to sign up, you have to have a lot of cardholders, and to get cardholders to sign up, you have to have a lot of merchants. So it's a problem it makes a problem for entering the market. And thus, there are complicated pricing issues. One side, as I mentioned, may have a zero price or even a negative price, but that doesn't mean it's a predatory pricing case or something like that, because they are simply trying to attract a lot of users on one side to make the other side more attractive. And similarly, the two sides of the market may have very different competitive conditions. So back in the day, when the most common two-sided market that we examined was newspapers, there were different competitive conditions on the side of readers versus the side of advertisers. Those were the two sides. And we might well bring, and usually did bring, a case, if we brought a case on the side of advertising rather than on the side of the readers. Now, this was back in the day when readers valued advertising in a newspaper, which I expect they don't so much anymore. But Professor Kim is not old enough to remember this, but there was a time when I would buy a newspaper in order to find out what time the movies were showing, or to see the list of jobs available that was not available anywhere else in a timely manner. In fact, as a footnote, I can still remember the day when the job openings list, which was called the want ads, said job openings for males and job openings for females. That's a long time ago. But those were the kinds of things one bought a newspaper for. And sure, you bought the newspaper to read the news, but you also bought it for the advertising. And if it didn't have any advertising, it was not as attractive to customers. Well, the more recent examples, the current examples, credit cards, video games, Uber, Airbnb, these are all two-sided markets. Next slide, please. So these provisions in the contracts of American Express with the merchants fall under the category of vertical restraints. And vertical restraints under U.S. antitrust law are generally examined under what we call the rule of reason. Some of them used to be so-called per se illegal, but that's gone away, and I think all of them nowadays would be under the rule of reason. And the usual methodology adopted by most courts in a rule of reason case is a three-step process. The plaintiff, the government or customers or whoever, excuse me, starts off by demonstrating an anti-competitive effect of that restraint in a relevant market. In step two, the defendant has their chance to respond, and they demonstrate that the challenged behavior may serve a pro-competitive purpose. This got much more important starting in the 60s and 70s when the Chicago School started publishing good articles using neoclassical price theory as a basis for understanding vertical restraints and showing that there could be perfectly innocent or even pro-competitive reasons for, say, a tying agreement or an exclusive dealing arrangement. Well, then in step three, the plaintiff has its turn, sorry, and it seeks to demonstrate that this pro-competitive purpose could be achieved in another way, in a less restrictive way. If the plaintiff can't demonstrate this, then the court has to balance the pro and anti-competitive effects. In AMEX, the district court ruled that the anti-competitive effects of the restraint on merchants outweighed any pro-competitive effects in that market, in the market, as I understand it, for merchants, not over on the other side. Next slide, please. Professor Kim, shall we break for your comments or go a little further? Okay. So, the district court ruled in the government's favor, said that this restraint was harmful, more harmful than necessary. But AMEX appealed, and the Second Circuit and then the Supreme Court overturned the initial verdict of the district court and said that in some two-sided markets, and I've italicized that word for a reason, in some two-sided market, the methodology changes. Now, this is the first, I believe, antitrust decision of the Supreme Court that actually refers to two-sided markets, that phrase. Although they've certainly had cases in the past that were about newspapers and other two-sided markets, maybe radio stations or TV stations, I'm not sure. But the Supreme Court ruled that with two-sided transactions platforms, again, that language is very important and I've italicized it, where the indirect network effects are strong, the required step one for the plaintiff changes. In those markets, the plaintiff must show an overall anti-competitive effect, taking account of both sides of the market. In step one, the plaintiff in its first step has to show an overall anti-competitive effect, taking into account both sides of a two-sided market. And in this case, said the circuit court, the circuit and the Supreme Court, plaintiffs had failed to meet this initial burden. In fact, they had probably not even tried. They did not believe they had this burden, so they probably didn't even try. Next slide, please. So, a couple of takeaways from the AMEX decisions. In a two-sided transactions platform market, the plaintiff's burden in a rule of reason case increases. The Second Circuit said DOJ had failed to meet its step one burden, showing that the restrictions made all AMEX customers on both sides of the two-sided platform, that is, both merchants and cardholders, worse off. And the Supreme Court basically said the same thing. The plaintiffs have not carried out their burden to prove anti-competitive effects in the relevant market. The plaintiffs focused only on merchant fees. We find this argument unpersuasive. Again, the plaintiffs have not satisfied the first step of the rule of reason. They have not carried their burden of proving that AMEX's anti-steering provisions have anti-competitive effects, that is, considering both sides of the market together, merchants and cardholders. Next slide, please. So, what are two-sided transactions platforms? That's a new phrase. The Supreme Court said two-sided transactions platforms are platforms with more pronounced indirect network effects and interconnected pricing. For example, not newspapers, because readers, they claimed, are largely indifferent to advertisements, which probably these days is true, as I said, didn't used to be true. But they said that the indirect network effects and connected pricing facilitate a single simultaneous transaction between the sides. That's the characteristic that the Supreme Court said is what distinguishes a two-sided transactions platform from just a two-sided market. And so ever since its decision, commentators have been arguing about what markets besides credit cards would qualify under the Supreme Court decision as two-sided transactions platforms. And my former boss, Macon Delrahim, when he was the Assistant Attorney General of the Antitrust Division, said, well, Uber and Lyft and Airbnb may qualify. Google and Facebook may not, because they're supported by advertising, so the instant transaction between the two sides is not taking place. And some activities of Amazon might qualify. But he was speculating. He didn't know, and as far as I can tell, nobody knows right now. So, next slide, please. With transactions platforms, how do we define markets? What's the lesson here? The Supreme Court decision says that the market is the transaction. The Second Circuit said in two-sided transaction markets, only one market should be defined, the combined market. In a credit card market, the merchants and the customers. The dissenting opinion in the Supreme Court case said, of course, the two-sided network nature of the market is important. Didn't really say you have to balance the effects of the two sides, but it certainly said you have to take account and acknowledge that there are two sides and they're related. But the dissent said the majority decision puts complements into the same market. And that is novel, to say the least, and not supported by previous decisions. Previous decisions in the antitrust world have always said markets are made up of goods that are close substitutes to each other. Indeed, when I first started doing antitrust, one of my bosses told me just to think of a market is that which may be monopolized. So you could monopolize a market maybe for baseball bats, but you wouldn't put a complement like baseballs into the same market. Baseballs are a complement to baseball bats, not a substitute. And by the way, in the most influential newspaper antitrust case that the Supreme Court heard years and years ago, the court held that in newspapers, advertising and readers are separate markets. And that's been the way economists and practitioners have thought about this for decades. So where do we go from here? That is very unclear. As I said, Makin Delrahim, certainly as knowledgeable as anyone about these issues, speculated on what industries or markets or sectors might be transactions platforms under the Supreme Court decision, but he didn't know, he was interpreting it. And at the end of this slide presentation, I have a few recommended reading recommendations, but boy, this case has provoked a lot of discussion in the literature, economists and lawyers and practitioners, and I couldn't even begin to list them all, but I do recommend them to you. It's a very interesting and very important argument. Professor Kim.
Well, I couldn't agree more with you yes, it is very difficult and important to have a relevant, good relevant market defined. But how about this example? Let's think about a movie reservation service, for example. Well, that they provide a service, and it enables a person wishing to watch a movie at a theater to make a reservation, and the theater to take the reservation from that person. Then the reservation service can charge the user, the theater, or both for the service. And that service is joint and inseparable, right? And therefore, isn't it natural to evaluate the overall, if any antitrust effects in both sides, to evaluate any kind of restraint in the service? What do you think?
I think it's very natural to examine the overall impact.
Right.
There are different views on whether, if there is an impact on one side, one should strongly consider or acknowledge an impact on the other side. But I think it is important, always important, to acknowledge the facts of a case. And in this case, it is clearly a two-sided market and indeed a transactions market.
Right.
But there may be, as I mentioned, different competitive constraints on the two sides. There is a market for movie exhibition, which may include homes and HBO, or may just include theaters, depending on the analysis. There is a market for customers seeking to make those reservations, but they are separate markets. And I would argue that if you are looking at the service itself, the matching service,
Right.
you would look for substitutes for the match.
Right.
You would not define a market as the customers and the movie exhibitors. You would define the market as different ways customers may reserve a movie ticket.
Right.
And there may be several. You may be able to go, I don't know, on Amazon or YouTube or whatever, to make that reservation, or you may be able to go on the movie theater's website to make that reservation. But those are the substitutes if you're looking at defining the market. And then there is a market of customers, and maybe they substitute, maybe TV shows are a substitute, or plays, or baseball games. And then there is a market for exhibitors, and maybe HBO and cable TV or plays or baseball games are substitutes on that side. but those are two different markets, and the customers and the movie theaters are not substitutes, and therefore, under all past antitrust scholarship and jurisprudence, as I understand it, I'm an economist, not a lawyer, they do not belong in the same market. They're separate markets.
Well, I agree with you that the movie exhibition and the customer are two separate markets. We are not taking two separate goods into one single basket. We are defining a service itself. And in order to define the matching service, you have to you need two markets, right? And how about for example, the Staples Depot case? They're defining a good of office supplies, right? And in office supplies, there are many goods, pencils, and the complementary goods and substitutes or something like that, and they include that kind of basket as a good. Well, sometimes we do that.
That is a very fair point, and we do that for two separate reasons. We do that either because there are 100 goods and they are complements, but they all have the same competitive characteristics. So all of them are sold under your example, by an office superstore. Or we do it because because it makes a difference to competition that they are all sold together. Is a sort of a bundled market. Like banks are, I guess, or used to be, I'm not sure, under the Philadelphia National Bank decision, that savings accounts and checking accounts and loans and so forth are a bundle that a bank must offer in order to get customers, even though they are complements, not substitutes. So I would argue, yes, you're a very good point. Those kinds of markets include complements, but it's either because for convenience, because all the complements have the same competitive effects, or because a seller in the market must provide a bundle in order to compete.
Well, the example you just mentioned, the newspaper case, that the advertiser and the readers, well, for the record, I'm old enough to know that. And what is important is the conduct we need to investigate. And that newspaper case was, if I remember correctly, is a tying behavior, right?
As I recall the case, which is an old one, it was either tying or exclusive dealing, but it had to do with advertising.
Right.
And
if the morning newspaper you advertise it, then you have to do it again in the evening newspaper. That's my understanding. I may be wrong.
No, it was either that or the opposite, because if the two newspapers were separate, if you advertised in the morning newspaper, you couldn't advertise.
Okay.
It was one or the other, but I don't remember.
Okay. So in that kind of conduct, then the only one market is enough to evaluate. So that's why we need to even if it is a two-sided market, we only need to define one single market to evaluate that kind of conduct. But the AMEX case is an anti-steering provision. Well, that kind of conduct will impact both the merchants and customers, right? So that's why I need to define two markets into one, defining the matching service.
I am not sure how. It's a very fair point. I'm not sure how the impact of the anti-steering provisions on cardholders, and there certainly is some impact, differs from the impact of advertising restrictions on newspaper readers. It seems to me those are both. There are impacts, there are indirect network effects, but they don't mean that the two sides are in the same market.
Any questions?
Okay, keep them in mind if you want to ask questions later, please. And I don't know if we can take questions from the ether.
The online? No.
No? Okay.
14 minutes.
Okay, I guess we better move along. Okay, next slide, please. Keep it going. There we are. Okay. AT&T Time Warner, a very important merger case that was brought by DOJ in 2017. In 2016, AT&T announced its agreement to acquire Time Warner for in the range of 80 to 110 billion, depending on how you count Time Warner debt. In 2017, there were reports that AT&T CEO Randall Stephenson was negotiating with the head of the antitrust division, Assistant Attorney General. That D should not be there. Sorry, Macon. The Assistant Attorney General, Macon Delrahim, concerning possible divestitures that would satisfy DOJ. Those negotiations apparently did not succeed. And so DOJ filed suit under Section 7 of the Clayton Act to challenge the merger. It was apparently the first time in many decades that DOJ had actually challenged in court a vertical merger. The district court judge ruled in favor of AT&T. DOJ appealed. DOJ did not, as it often does, seek a stay of the decision, so in order to keep the parties separate while we appealed. In fact, the judge in the case had gone to the unusual step of saying, DOJ, don't even bother to ask for a stay. This case has taken a long time. Please don't waste our time. So we didn't. And in February 2019, the appeals court unanimously affirmed the district court decision. Next slide, please. So the basics here. AT&T is and was a content distributor. It has cable TV operations in various regions of the country. And at the time, it also had a satellite TV operation that operated throughout the country, DirecTV. Time Warner is and was a content creator. So its subsidiaries like Turner Broadcasting, which very importantly we'll talk about, includes CNN, Warner Brothers Movie Studios, and HBO, are content creators. They create the content that distributors like AT&T and DirecTV distribute to the final customers. So this is a vertical merger. AT&T buys content from Time Warner, sells it to us. As I said, allegedly the first DOJ challenge to a vertical merger in maybe 40 years. DOJ's stated concern, and with a vertical merger, as any economist can tell you, you could be concerned about downstream issues or upstream issues. DOJ was concerned about a downstream issue, that the merged firm would discriminate against AT&T's competitors, its downstream rivals, when it was licensing Turner content to them. So whether it was the other TV satellite distributor or other cable systems that competed with DirecTV, the concern was that once the merger took place, AT&T would no longer be a disinterested licensor. Turner would no longer be a disinterested licensor to those downstream competitors. Next one, please. Well, AT&T did something which has become pretty common, and I don't know, again, as an economist, not a lawyer, I don't know if there have been definitive legal rulings on this tactic, but AT&T proposed and created and presented to the court a commitment to non-discrimination. It committed in signed contracts to other distributors that it would not discriminate among distributors. And this commitment would be enforced by binding final offer arbitration. At least in the US, we call final arbitration baseball arbitration because that's how baseball salary disputes are arbitrated. In baseball or final offer arbitration, each side makes a final offer and the arbitrator has to choose one or the other offer. It cannot choose something in the middle, which another arbitrator might be inclined to do. And the theory is that this should incentivize both sides to make their final offers reasonable. I don't know that this has been proven empirically to be superior, but it is considered to be that way by many. And what AT&T certainly had in mind is that this was pretty much an identical offer to, or pretty much an identical relief proposal or concession or consent decree that had been successful in a previous similar merger. In 2011, NBCU, which is a content producer, merged with Comcast, which is a content distributor, a cable TV system. And DOJ, and in that case, the Federal Communications Commission also had joint jurisdiction with DOJ. In that case, DOJ and FCC accepted this remedy, accepted a non-discrimination pledge enforced by final offer arbitration. So AT&T said, so what's the difference this time? This is the same remedy that you accepted 7 years ago. The differences this time, I would say, my very own personal views. First of all, AT&T had carefully, I would say, structured this deal to avoid FCC jurisdiction. So it didn't have to satisfy two government agencies, it only had to satisfy one, which would certainly make winning litigation easier. DOJ had over the years, and especially in recent years, been souring on behavioral remedies, that is, non-structural remedies, agreements, maybe even contracts that DOJ and the judge would have to monitor going forward. And I would say some perceived weaknesses of the non-discrimination commitment, which I'm not saying DOJ believed this, but as I look at it, if Time Warner promises not to discriminate, it could still raise its internal price to itself and then raise everybody else's price. And that would be non-discrimination, but it would be based on an increasing of its internal price that means nothing, or arguably means nothing. So in my personal view, those non-discrimination commitments are often not very powerful because it's not an external or exogenous number that you're not discriminating against. The company can change that number, but that's my own view. All right, this case was a duel of heavyweights. DOJ had, next slide, please. DOJ had Carl Shapiro, very distinguished professor at Berkeley on the left, my former boss, and one of the authors of the 2012 DOJ FTC merger guidelines. The FTC had, AT&T had Dennis Carlton, another very distinguished industrial organization economist from the University of Chicago. Also my former boss, although he never wrote any guidelines. But those are certainly two of the heavyweights in the industrial organization world and in the world of antitrust litigation. Next slide, please. A little bit of background on the bargaining models that Professor Shapiro used. These were very important to the case. He started with the view that a successful bargain creates joint surplus. The world is better off when you and I bargain and we agree. The bargaining there, he distinguished between, and others have been distinguishing also between bargaining power and bargaining leverage. And those two terms are very often confused or used as synonyms, but economists in the past few years have distinguished them. Bargaining power is the ability to claim a certain share of the joint surplus. So one bargainer may be a better bargainer, may be a more experienced bargainer. If I'm bargaining for a used car price, I'm a lot less experienced than the car lot that's selling it to me. But in general, if you are looking at bargains between two big companies, they're probably going to be similar in skill. What the literature suggests is that there will only be a significant difference under two situations. First, if one side is more impatient than the other, that is, it has a higher discount rate, so it's more anxious to reach an agreement, and therefore it may accept less of a smaller percentage of the joint surplus, or risk aversion. If one side has a greater fear of no agreement, in that case, it might be the one to accept less of the joint surplus. But otherwise, we especially with two large businesses, the usual assumption with this bargaining model, which by the way is called Nash bargaining in general, after John Nash, the beautiful mind, subject of the biography and the movie that many of you may have seen. Under Nash bargaining, said John Nash, two negotiators would usually split the joint surplus 50-50. And so he said, let's go with that assumption as a sort of default assumption. Next slide, please. Now, in a Nash bargaining situation, each bargainer has a fallback position or a disagreement outcome. So the seller has what we call a seller min or minimum. That is, he's not going to, let's say he's not going to accept less than $6 for what he's selling. That's his minimum. If you insist on less than $6, he's not going to sell it to you. He has other options or he's going to go away. The buyer comes into the deal with a buyer max, a buyer maximum. And let's say the buyer in this case will spend up to $10, but not more. If the seller insists on more than $10, the buyer's going to say, I'm going away. In the jargon of bargaining theory, those two numbers are the BATNAs of the two bargainers. The best alternative to no agreement, the BATNA. And it's very clear, certainly in this case from the evidence, that both parties to the negotiations for content for distribution in cable or DirecTV have considered their BATNAs very carefully. They go into these negotiations with a very specific strategy, including a very specific BATNA. And the bargaining leverage, as it's come to be called, is basically a measure of how good or bad that BATNA is for each party. In other words, how credible is it for one party to threaten to walk away and take the disagreement outcome? If that's not very credible, then the party has not very much leverage, because the other side is probably likely to know that the bargaining partner cannot walk away and so has to reach some agreement. Well, The difference between the two disagreement outcomes, the seller max and the buyer min, is called the bilateral surplus. And that is the joint gains from a successful agreement. And again, Nash bargaining predicted that in most cases, the bargain that ended up with two experienced corporate negotiators would be 50-50 split of the surplus. Again, it's sort of a default position unless you have a reason to believe that something else is going to happen for some very good reason. Next slide, please. So Shapiro's model presented that model. Shapiro's testimony presented that model, and then noted that the changes in the BATNA of one side may change both the size of the bilateral surplus and the outcome of the bargaining. In this case, Professor Shapiro argued, as I mentioned, if AT&T acquired Time Warner, that would increase Time Warner's willingness to be a tough negotiator, to have a higher seller min and be more willing to accept no agreement. Why? Because the buyer of Time Warner's content is a competitor of AT&T, now the owner of Turner. And therefore, if one of AT&T's competitors downstream doesn't have the Turner content, it's a weaker competitor to AT&T downstream. Again, you could make exactly the corresponding arguments and model about upstream issues. But in this case, DOJ was worried about the downstream. So in this case, if the seller's BATNA increases up from 6, while the buyer's BATNA doesn't change, still at 10, then the price predicted by Nash bargaining goes up. And let's say it goes up from, the seller's BATNA goes up from 6 to 7. Now a 50-50 split results in a price of 8.5 rather than 8. And that was basically Professor Shapiro's prediction, obviously more precise and applied to this market than that. But the basic prediction was the merger increases Time Warner's seller min, and therefore, all else equal, should increase the price predicted by Nash bargaining. Please.
If I remember correctly, a few slides earlier said the AT&T proposed a non-discrimination commitment, right? Mm-hmm. Well, then how is it possible to deny the Time Warner's content to AT&T competitors? Doesn't it violate that kind of commitment?
Yes, that's a very good point, and it raises the issue which I mentioned of if you have a basic merger case, and DOJ thinks it's an anti-competitive merger, if the party brings in a settlement, is the judge supposed to consider the settlement as a fact of the case, or is the judge supposed to focus on the original? So in this case, yes, you have caught me being a little bit careless. So with the proposed settlement, DOJ would be worried that the non-discrimination promise, as I suggested, would not be effective. And DOJ could increase its internal price for all sorts of reasons that it claims of increased costs and so forth, and which doesn't really mean anything to AT&T, but in that way increase the price of its downstream competitors and therefore disadvantage them without necessarily having to change its own price. So you're correct. Under that non-discrimination agreement, the merged firm would not be able to deny content. It could simply charge more or make various conditions more difficult in the contract.
Well, then doesn't it contradict to the famous double marginalization problem? If the vertically integrated firm, then they can lower
Yeah.
lower the final prices. And you said that they can increase all the prices, and that does not contradict with the non-discrimination
Well-
promise. But in fact, that may not be the case, isn't it?
Well, fair point. I'm arguing that the internal price charged by Time Warner to its parent, AT&T, is basically a fiction. In the same sense that when I look at, for example, a European railway case, and the infrastructure owner also operates trains, and it promises non-discrimination in the infrastructure charge, it doesn't really care because it's an internal price. You're right about double marginalization. I'm going to talk about that in a minute. But in terms of non-discrimination, I'm arguing that in either of those cases, the internal transfer price is a fiction and does not necessarily affect the vertically integrated firm's downstream price or other terms, and that it would be very difficult for you or me as a plaintiff to demonstrate otherwise. Okay, thank you. Next slide, please. Starting with DOJ's litigation difficulties, which is even more my own view than anybody else's, and I emphasize that. Please do not attribute any of these views to DOJ. First of all, was a widespread belief that the only reason DOJ brought its first vertical case in 40 years was because President Trump told DOJ to sue because President Trump hated and hates CNN, which is a lefty-oriented news broadcaster. Many people believed that. Many people wrote that. It was AT&T tried to assert this in court, and I suppose would have been demanding DOJ witnesses to testify what they promised to President Trump, I suppose. But the judge said, no, we're not going to consider that in this case. I don't know whether it happened or not. I'm not going to demand White House phone records. We're going to decide this case on the antitrust laws. So AT&T was not permitted to use this argument in court. It wasn't in the decision or anything else. But certainly that was in the atmosphere, that many people believed that was why DOJ changed its behavior. It probably didn't help that the AT&T litigation team stayed in the Trump Hotel and paid the very high room rates that the Trump Hotel charged, but that's an aside. The second reason I would argue, and this has been argued by others, is that Professor Shapiro accepted the assumption of the elimination of double marginalization. That is, the assumption that a vertical merger on its face reduces the costs of the merged firm because the merged firm takes account of the downstream profits and price while the separate firms do not, or the upstream firm if it's vertical, or the complementary firm if it's just complements do not. DOJ has very explicitly over the years, including from Macon Delrahim, been backing away from automatically assuming that vertical mergers result in efficiencies from the elimination of double marginalization. Macon Delrahim made a very good speech about it. It's in the new guidelines that were issued last December that we will not automatically accept the elimination of double marginalization as a vertical merger efficiency, but Professor Shapiro did. And so that put some money on the AT&T side of the outcome from the beginning. The judge also was skeptical about the Nash bargaining model. In particular, he was skeptical about the 50-50 assumption and asked Professor Shapiro why 50-50 was the right assumption. And arguably, Professor Shapiro didn't have a very good answer, except that that's what everybody does. And John Nash won a Nobel Prize and he did it. But I think most people would say he didn't convince the judge. A very important factor, I think, that is emphasized by Dennis Carlton in the book chapter that he wrote about this case, which I refer to at the end, is that I think purely by chance, this was the same judge who was presiding over Comcast NBCU. And so he knew in detail the Comcast NBCU consent decree, non-discrimination provision, and every year DOJ had been assuring him that it was working. So that put DOJ arguably, and I'm just repeating what Dennis Carlton said here, in a awkward position. And Carlton was able to back this up with empirical evidence that he claimed showed that in fact the decree had been effective, that the NBCU Comcast merger had not resulted in increased prices or a loss of competition. Well, after all that sound and fury, to quote Macbeth, the merger took place. I'm sorry, next slide, please. The merger took place. It was not a profitable merger. AT&T 2 years ago, pretty exactly, sold off Time Warner to merge with Discovery Channel to make a new content company. AT&T claims it didn't lose any money on this. People who have examined it claimed it lost tens of billions of dollars. I don't know. The New York Times had a long article asking if this was the worst merger ever based on how much AT&T may have lost. That author is one of the ones who claimed it lost $42 billion. A Rutgers business professor wrote an interesting article claiming that when either companies put together mergers or consultants suggest them, or even DOJ or FTC analyze them, we should consider the cultures of the two companies, and that a business school professor should understand that two companies' cultures might be very different. And as the Times article suggests, it would be hard for two company cultures to be more different than AT&T's and Time Warner's. In any case, as sort of a footnote, economist Timothy Taylor, after looking at all this, says, oh, by the way, there's no, all this about the merger not working kind of maybe conceals the fact, if it is a fact, that there's no evidence that the merger actually harmed competition. So that's an interesting thing to examine also. So final slide, I give you, as I say, some reading recommendations on both sides. I think both sides are represented here. No, I think I give you a biased group on the AMEX case. I don't think I give you anybody defending the AMEX case. I do give you Dennis Carlton defending the AT&T outcome. But that's the conclusion. And Professor Kim, over to you. or to our audience members.
Okay. The both FTC and DOJ can investigate mergers, right?
For the most part, yes.
Right.
There are a few minor exceptions, industries,
see.
but yes, for the most part.
How are such merger cases assigned to two regulators? First come, first served?
Very good question. And it has been a controversial question over the years. The fact that both agencies exist and they're not identical, but they do many of the same things. I think anyone would admit is a historical accident. And if one were designing it now, we wouldn't have two agencies. The question would be which one to get rid of, which is the controversial part. But in fact, with mergers and with any investigation except for cartels, cartels are investigated criminally and only DOJ has criminal authority. But other than cartels, any merger, any abuse case, one side has to go to the other and say, I want to investigate this. And the other side can say, fine. The other side can say, no, 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 I want to investigate this. And then we argue. Most of these decisions are pretty easy because we have decades of history, and over those decades, we have a sort of path dependence that DOJ knows the steel industry very well, and FTC knows the grocery industry very well. And so we would not really contest one of those. But, you know, if it's a new kind of industry that neither one of us has a lot of experience in, or if it's, you know, a nice big case that both of us want and both of us have some experience, like a Microsoft case in the 90s, then we argue about it, and it can come even to flipping a coin. But, and as I understand it, along with the coin flip comes, okay, but I get the next one. But we do all of that with any investigation in order to avoid duplication. And as a staff economist, I am not allowed to make any calls to any outside party about a case until DOJ has been given official clearance.
Well, if I remember correctly, there's some famous banking merger cases, and DOJ was not satisfied with the other regulators' decision, and they brought the case to the courts. Is it possible to bring the case to the court if you're not satisfied with the FTC's decision?
If we're not satisfied with the FTC's decision, we can take the case and bring it to the courts. As far as I know, it has only happened once in all of our history, and that was the first Microsoft case. And what happened was FTC investigated, and the staff recommended a lawsuit. They took it to the commission, which decides whether to sue or not. The commission has 5 members. One of the members was recused. And so the commission came to a 2-2 tie. I'm sure when that happened, the champagne corks were popping in wherever Microsoft's headquarters, Richmond, Washington, wherever its headquarters is. But DOJ said, no, this isn't like double jeopardy. This is FTC decided for whatever reason not to sue. We can investigate. And so DOJ took over the case when FTC could not reach a decision. As far as I know, that is a single time in history that has happened. Now, in terms of regulated industries, most regulated, basically the laws are industry specific. And in most regulated industries, banking, electricity, telecommunications, the regulator can block a merger, or DOJ can block a merger. And we coordinate and interact with the regulatory agencies. Certainly, they have a lot to teach us about the industry. We hope we have something to teach them about competition. We try to come to the same conclusion, but sometimes we don't. And as you say, in banking, there have been some cases where the regulator said, okay, fine. The regulator historically has been more worried about the soundness of the system. The soundness of the system may get better with concentration. So the DOJ has sued. We have also sued in not quite a regulated industry, but Defense Department cases where the Defense Department was fine with the merger, but we decided to challenge. As far as I know, the only industry we don't have that authority is the railways. And again, it's an accident of the litigation of the laws in each sector that if two freight railways want to merge, we basically only have one national passenger railroad now. But if two freight railways want to merge, we are empowered and even I think encouraged by the law to investigate and give our opinion to the regulator, but only the regulator can decide. I think that's the only one where we don't have authority under the Clayton Act to bring a case.
Well, another question is the Professor Shapiro, take the elimination of double marginalization in his report. And the DOJ was not satisfied with it.
I didn't say that. I said I was not satisfied.
Okay, okay.
I'm not giving DOJ's positions here.
Well, the end of the question then.
Questions from our colleagues? Yes, there's at least one. Good.
I have a question. When I think of the Shapiro's model, so if there is some concerns with transferring market power from upstream to downstream, then maybe the model would be a little bit changed. In that case, it would be easier to make judges understood about his model and including his viewpoint. So in that case, we can think that there may be some discriminating effect to the market, which should be the opposite offered by the Dennis Carton's opinion. So I'm wondering about your opinion if this type of concerns included into the niche bargaining model, then what happens? Yeah.
Well, if you don't believe that a non-discrimination provision can be effective, then you're going to take more seriously the finding or the suggestion and evidence that the merged firm would discriminate. It doesn't really affect the bargaining model. The bargaining model still says the company would like to discriminate, but the non-discrimination contracts with the other distributors say that it won't be able to, and the judge may even enforce that. So it doesn't change the bargaining model, but then we can argue about, is a promise not to discriminate effective?
The starting point was 50-50 because the judges criticized about the Shapiro's model while pointing out why the Shapiro started from the 50-50. So I thought that was the point when I read the Shapiro's paper published in 2021 at Review of Industrial Organization. So instead, and if his starting point is based on the real world situation between the AT&T and the Time Warner, then maybe since the AT&T has the different position compared to the Comcast, so that the discrimination effect would exist in this case. That's my guess. Yeah.
Yeah, and I don't remember the details of that article. He may have argued that discrimination would be more of a concern in the AT&T case because AT&T had DirecTV. So DirecTV was everywhere. So in every market in the country, you would worry about the discrimination. Whereas with Comcast NBCU, you would only worry about those regions where Comcast had the cable TV franchise. That could have been his argument. I don't remember the details of the paper, but that would be a reasonable rationale for why the same relief, the same contracts would not have the identical effect. Good point. Thank you.
Sorry. My name is Joseph Choi from Hankuk University of Foreign Studies, like 10 minutes away from Korea University, so I had a chance to participate in your wonderful workshop. Thank you for your presentation. Actually, Dr. Pittman, actually, your presentation was really perfect, so I don't have any big question. But actually, we have a really good, some important kind of cases nowadays, like a two-sided market, like, neighbor case, and also the Kakao mobility case. And those two cases you explained today were really relevant for those two cases. So I learned a lot from your presentation. And I never thought about the, Warner Brothers merger case, but like, I found some economic theories in the case. So I learned a lot from your presentation. I have one simple question. Maybe it's just classic, but like, what do you think about the market definition in two-sided market? Especially the AMEX case was a little bit complicated. And some argue that this is a vertical restaurant case, so market division should be really clear and accurate. Some said not really. So do you think it's the difference between transaction platform and non-transaction platform? I mean, when we define the market in those two different kind of the business models, shall we define the market differently or the same? And the second is like, well, then what if the case is like a horizontal restaurant rather than the vertical? So should it be like a different or the same?
Boy, good questions. Did I mention I'm speaking only for myself and not DOJ? As I said and discussed with Professor Kim, I think we are at a position of great uncertainty after the AMEX case, how to define markets in future transactions markets. Indeed, we're at a position of uncertainty as to what exactly a transactions market is. What was the phrase? Instant transactions? Something like that. Simultaneous?
Two-sided transaction market.
Two-sided transaction market. So as I said, even Macon Delrahim said he wasn't sure what a two-sided transaction market was. So does this change how this doesn't on its face appear to change how we would analyze a standard two-sided market case that we used to analyze with two separate markets. On its face, it only changes how we analyze this two-sided transactions market. But I think it is very uncertain now, and people are arguing about and trying to figure out and waiting to see how the courts interpret this decision as to how we're going to define markets in those cases. In the next credit card case, how are we going to define markets? Your question about horizontal restraints is a very interesting one. I haven't heard this question and this issue applied to horizontal restraints. Horizontal non-cartel restraints, of course, are also considered under the rule of reason. So it's possible that this new idea would apply also to horizontal restraints in a two-sided transactions market. I have not thought about this and not heard anyone mention it, but it's a very good question, maybe for your next article. Thank you. Any other questions?
Well, just
Microphone.
when we evaluate merger case, you don't have to define relevant market. You have to analyze, investigate the economic effects without defining relevant market, isn't it?
That's a very good question.
Well, when you analyze the two-sided market, that kind of restraint, according to the rule of origin case, you have to demonstrate an anti-competitive effects in a relevant market. But is it possible to do it without defining relevant market?
I mean, that question applies to merger analysis generally.
Right.
And it is a very fair argument, and many economists make it, and some judges are making it now, that the only reason we define relevant markets is to figure out what the competitive effects will be. So if we can examine competitive effects directly, why are we bothering about market definition? Yeah. So that's a very fair question. The last important case that I remember where a judge addressed it was our case involving tax preparation software, which was H&R Block and Tax Act. I don't know how many years ago, but say 7, I don't know. But the judge in that case, as I recall, said exactly what I just said. Look, market definition doesn't seem necessary. We have all this evidence of direct competitive effects. But I think the law requires us to define markets, so I'm going to define markets. So I think we are facing a future of, if we have really good competitive effects evidence, some judges may decide we don't need to define markets.
But if I remember correctly, the 2010 horizontal merger guidelines, it says the relevant market is a starting point, but not necessary. Am I wrong?
It's possible that it says that. I don't remember for sure. We've found before that you know the guidelines better than I do. It's possible that it says that. I mean, those guidelines were written basically by Carl Shapiro and Joe Farrell, and I'm sure they believe that. So if they said that, it was as economists, not lawyers. But I believe they might have said that. Yes.
Any other questions? Any questions from the floor? No? Okay. Well, the Dr. Russell Pittman's presentation today was very helpful and excellent as usual.
Thank you.
Now I think it's the time to close the second series. And if you have any questions further, then I'm going to close this lecture.
And thank you all so much, including those watching from their offices. Thank you everyone for participating. Appreciate the questions.
네, 그럼 여기서 오늘 렉처 시리즈를 끝내도록 하겠습니다. 감사합니다.
Thank you. 감사합니다.